Good evening, everyone. Brian Ponder here, Brian the credit lawyer, and we have a very special guest, Vance Dotson, Vance the credit doctor.
Attorney in fact.
Well, since you're a doctor, what do you think about all this COVID-19? Can you give us a vaccine, anything for us?
I got the best vaccine. Stay in the house.
That's a good one.
Yeah, stay in the house.
Good one. Well, look, let me see here. Good evening, everyone. We have about 15 people on here. More people looks like will be jumping on. We had such a good time last night in our session with Mr. Credit Doctor here. We brought him back, and we're gonna open it up because we got through 10 hot topics. A lot of people said, "Oh man, I wish I could have asked you about this, that, and the other." Well, look, tonight's your lucky night. We're gonna have this thing open floor Q&A. We're gonna talk about credit, debt, debt collection. We're gonna pull up some laws if we have to. So we're gonna open it up, and I think Warren already indicated he had a question for us. So everyone, if you want to remain muted until you have your question, that would be great. Keep everything clean. Vance and I will stay unmuted.
Hello.
Hello, good evening. So yeah, whoever wants to unmute and ask their question, go right ahead. I know Warren or someone else wanted to go ahead and jump on.
Sure. I got a client who got a phone call today, and the debt collector left him a message, and I want to check. It seems like it's probably a clear violation, but I want to play it for you and see what you thought of it.
Go right ahead.
That's cool with you. Here we go.
The reason I'm calling is a partial legal complaint received into your name and social security number. Last week, your release order in regards to the complaint that has been filed against the Creditor will be at your residence or place of employment within the next few days. You are required to be present on form of state sheet identification. If you have any questions or would like to reschedule a service date, you can contact our claims office at 844-934-0426 in reference to your case number on file 9919984. Erica,
So that was the voicemail they left, and then she called him back. Was like, "Who are you?" And they said, because she's asked them why they're threatening her, and they said, "Well, no, we're not threatening you." He said, "Sure sounded like a threat. You're saying you're gonna come to my house and my place of employment," and they never said, we're a debt collector or anything like that, which they were. They were trying to collect on a credit card, and so they never said who they were, except they said that who the company wants you to talk to. But
did they give the company's name?
It was independent. I think independent associate.
All right. Well, I'm gonna tell you what I think. Most of the time, those companies like that, you can't find them. They're working virtually, and they're banking on finding someone that's gullible enough to pay them. But if you Google this company, can't find them. If they won't give you their address, even if they give you their name and address, if you look it up, the last time I've heard one like that, I looked it up. It was in New York at a UPS office, like a non-brick and mortar. Those people work in stealth. They're definitely violating the FDCPA, but the problem is you can't find them. They're virtual debt collectors that violate the law, and you just can't find them. It's very tough. What do you think about that, Vance?
Well, I had a crazy call like that similar a couple of years ago. But yeah, like you say, it's hard to obtain substantial information on companies like that because, like you said, they're working virtual. I mean, it's just hard to find the companies like that. But keep recording the calls, because that's great evidence. A lot of the cases that I have with recorded calls, the cases don't last too long in federal court because it's clear what they did on recording.
Mm-hmm.
Is it legal for them when they because they like to call you, even not just these people but other ones, they like to call you from like different numbers. I know Portfolio will do that. I've seen them do that where it'll come in like a number from Atlanta or a number from then they'll call one from a number that'll come in from, like, let's say from our area or something like that, to try to disguise who they are. I think is there anything illegal about that?
Yeah, they that could be considered unfair practice, deceptive practice. Being deceptive. Obviously threatening to come and serve you something and they had no intent on doing it. Like that call, I think I heard. All those are violations. So, but you do the right thing, recording it, and then ask for the company's name, address. Because like I said yesterday, these companies technically they're going to try to identify you to make sure who you are, but you should try to identify them to see who they are. But I advise all people, they should never give identifying information to verify themselves. So calls like that shouldn't get far. And I would just recommend telling them not to call. But again, as y'all remember yesterday, a true do not call, cease and desist has to be in writing. But, yeah, that's definitely a violation when they start doing all these threats and all that random stuff. Warren.
Hey, Brian, I had a question for you. It's about inaccurate credit reports. So I have my TransUnion, and of course they have on there like the different months throughout the year. However, I have a lot of blank information that's in there. So they'll have information on January and February, but like March, April, and May is blank, and they're also saying that I'm 30, 60, 120 days late.
Oh, really?
Then it'll kick back up like the 5th or 6th month. Is that inaccurate or?
Well, the lates, if they're inaccurate, would be inaccurate. The blanks would be incomplete. So, yeah, that's that. I mean, yeah, the incompleteness is those blank months that are not reporting.
So I can just use your inaccuracies and the inaccuracy and incomplete letter and send that to them so that way they can fill it out.
Yeah, is this you say a credit card?
Yes, this is for Capital One credit card.
Okay, is it still active?
Yeah, but I do have one for Credit One that's actually charged off, and it's the same thing. It'll say, some months with the balance and all that, but some just will be blank.
So that charged off one, you want to go for a credit card deletion on that one.
Right.
And then the one with all those late payments, are those, were there some actual late payments on that?
Really, I'm not sure if it's late or I just didn't pay it, but it's still in there.
Yeah, so that card's still active. I would suggest on that card, go ahead and shred that card up, put it in the trash, let trash man get it, report that particular card stolen, and ask for a new card number. See if they start a new card number, and probably delete that old card number if they do. If they don't, then you can go through the dispute process trying to delete those late payments, because you got some inaccurate lates and then some incomplete months. So,
okay, got it. Thank you. And I had another question about the soft and the hard inquiries. I have your book. Well, I haven't got it yet, but I got like the PDF version, and it was in something about the inquiries. Now, is this for hard or is it for the soft? Because I do have some soft inquiries from some collection agencies.
All right. So the inquiry deletion only deals with, or you should care about, are the hard ones. So the hard inquiries are the ones that you want to get deleted, because the soft ones, the deletion doesn't matter because they don't affect the credit. Now, with debt collector soft inquiries, what you want to do is the $1,000 demand for unauthorized inquiries. Because if you are of the position that a debt collector has no business inquiring about you, then they perhaps pulled your report without permissible purpose or under false pretenses to say that you owe a debt and they're trying to find you. And so in that case, I would use the $1,000 demand inquiry letter and try to get them to pay you for violating your privacy and pulling a report. They're going to try to say, oh, we're trying to collect this debt. Well, nope, that's wrong. That's not mine, or whatever the case may be. But, you know, yeah, for the soft inquiries, you're not concerned about deletion of them. You just, you can attack any unauthorized pulls.
Okay, thank you.
Uh-huh.
I have a question.
Oh, sure.
I had an account with Ashley Furniture, and it was all paid up. And significant, I forgot the name of the company. Well, they took it away, and probably because my daughter got a student loan, and I co-signed for it, and 2 of them went into default.
Oh.
So, and my credit went down.
Yeah.
So I'm not sure, but I paid that on time, never had a problem. It was, you know, I hadn't done anything on it for about a year, and they just pulled it away.
Mm-hmm.
Can they do that?
Oh, yeah. They give it and take it away. Yeah, they can. So, yeah, you'll see that. Sometimes you'll see places decrease your credit limit when they see your credit is getting a little sketchy.
Yeah, they have done that too.
And then they can ultimately close it. So obviously, once you get your credit back where it was in a better standing, I'm sure they'll re-extend credit to you. But yeah, that happens, definitely.
Well, I have a private student loan. My daughter does. I co-signed for it.
Yeah.
And I think they default after 120 days.
Uh-huh.
But I can't remember because it did go into deferment. Well, their deferment was only for 2 months. And so they charged off 2 of them, and 1 is still active.
Mm-hmm.
So he says, well, I can pay whatever I want on the charge off. And I said, well, you got paid already because it was a bad debt. He said, yes. So I owe $70,000 on that charge off. So what do you do?
With that student loan?
I was going to contact you. I was going to get the student loan package, and I'm like,
you get that student loan package.
Yeah, because I'm like, this is crazy.
Well, I mean, that's sort of obvious. You need to delete. Well, you delete that student loan, get that student loan package, and get to work on that. Try to get up out of that.
Private loans are different than the federal loans.
Yeah, absolutely. The student loan deletion package, it doesn't matter whether it's government backed or private. But yeah, you know, you definitely want to work on that.
Okay.
Let's see.
I have another question.
What we got here?
Anybody else has one?
Go ahead. All
right. So on your Legal Shield plan, I was reading it, and it's saying that you can review up to 15 documents. Is that including like your credit report as well? Like if I wanted to send that in along with some of the letters that I've drafted with your assistance of your letters?
Yeah, they review your letter documents. Credit report itself, I doubt it. That's not considered a document, but they might. You know, in conjunction with the letter, I would certainly say yes in conjunction with a letter, but just say, hey, here's my credit report. Will you review it? That's not document review. Document would be a letter, contract, But you see, yeah, I would do it like that. Someone was asking, is your student loan package inside of your book? No, that's a separate package. I'll post a link to that. Richard M asks, how do you get an old student loan removed? It's 10 years old. Well, I can assure you, probably when you say 10 years old, student loans are sort of like mortgages. They're paid over a long period of time. So even though it's 10 years old, if the payment terms are still active, that account's still active. Perhaps, anything over 7 years in default won't show up on the history. But anyway, to get it removed, you have to do what's called I have a student loan deletion package, and that applies to active loans, old loans. I've used that for, just any student loan. It's a student loan deletion package that I have. And I think I'll post a link while we're talking here. No problem, Richard. Vance, you have any experience or tips with respect to that?
Yes. So looking at it, it's the title, student loan. I never look at it like, the title. And so I always look at, just the validity of everything that's in that account. So all the paperwork, and if anything that's missing, that's vital to that account or the information, that's what I'm going to attack, because the thing is incomplete, inaccurate, or unverifiable. So a lot of people must understand that Nailnet, Aquin, whoever it is, it doesn't matter. So understand that, say for example, Nailnet doesn't extend credit. So they're just a servicer, so it's laws that they must obey when interacting with consumers, when interacting with consumer disputes and stuff like that. So that's a key thing right there. They're a servicer. They didn't extend any credit to any consumer. They're just a servicer.
Mm-hmm. Let me see.
So
mine was through Wells Fargo. Well, I guess private loans, are they still the same? Because they serviced and did the loan.
Well, to come to a resolution on your problem, you might want to dispute with the consumer reporting agencies first. And then once you get the reinvestigation results back, if you're still not satisfied, you need to start disputing with, in this case, Wells Fargo.
Mm-hmm.
And so you might want to just see what the agreement is. You might want to get the accounting paperwork. You might want to ask them, how do they come up with this certain amount? Because they have to tell you basically what the interest rate is, where all these fees come from, and how do they get to this certain amount. And it has to be broken down. And so that's the law that's governing your issue.
Thank you.
Is the Fair Credit Reporting Act, and then you have the Fair and Accurate Credit Transactions Act. So just I want to go back on Warren's issue when he had that recording. So back in about 2008. So basically I'm always putting tips on Facebook, telling people to record the calls and just have proof, whatever that they're talking about. And so back, like I said, this is 2008. 2008, a guy recorded a call. Debt collector was using profane language. And so 2010, we went to trial, and he got $1.5 million. And so that's the largest FDCPA verdict still in America since 2010, and that was a North Texas case.
Mm-hmm.
And that case started over just a simple recording.
So Vance, that brings us to people need to record. If they're in the process of dealing with debt collectors, get a call recorder app and record all those calls coming in. So you can preserve that evidence. It's going to be very difficult to prove that someone said something like that call Warren played without a recording.
Yeah. I brung a case, I want to say probably about 2.5, 3 years ago. It was a law firm basically in Oklahoma City, and the lawyer, I went to his office with a consumer, and it's two cases really. I had the recorder in my pocket, and so the lawyer's just talking, and we filed suit in the Western District, Oklahoma. I think that case probably lasted about 2 months, and I think the settlement was around $8,000 or so like that.
Mm-hmm.
So recorded evidence is very powerful in federal court, because we had a way, basically a Google link. It was a link that we put into the complaint. So basically, we had ability to track it. And so once we reviewed it, once we set it up in a complaint and reviewed it like a hyperlink, we had the ability to track, how many times it was played. So we knew if the judge's clerk viewed it, we knew if the judge viewed it, or the attorney or the opposing attorney, because it was a hyperlink. So them cases like that often settle quick. And so I think it's a question about basically using recordings in court. Yes, you can use the recordings in the courts. But to be clear, so I'm in Oklahoma, and so if I record a call or I'm recording a call here in Oklahoma, I don't have to tell the other person that, hey, I'm recording a call, because Oklahoma is a one-party consent state. So what happens is, if I call California is a two-party consent state. And so what happens is, if I'm calling to California, two people have to be on the phone, that two people have to be on a recording, knowing that the call is being recorded. I never worry about that, because 100 times out of 100, debt collectors usually say, all phone calls are monitored and recorded. So I'm basically clear of that issue.
So you want to look up the wiretapping laws, because every state is different. So you could be in a state where it's a one-party consent. That means just one of you. So one-party consent means as long as one party to the conversation consents, then you can record the call. If it's a two-party consent, then the other party that's on the line has to consent.
Based on the state. Also, you're saying based on the state?
Yeah, it's state by state. So each state is different.
Okay.
You either have a one-party consent or all parties consent.
I believe there is about 12 to 13 states where it's a two-party consent state. But typically dealing with debt collectors,
12, yeah.
they give you the disclosure, hey, the phone calls is monitored and recorded. So you really, from there, you don't have to really say, hey, and I'm kind of recording this or whatever. Can I record this? Don't worry about it.
Okay.
Let me see. I think I can pull up something. I'm not sure about this source, but I'll pull up. I'll show you.
Can I get Warren to give me that phone number to that collection agency?
Warren's still there.
You there, Warren?
You there, Warren?
Yeah, I'm gonna throw it up in the chat here real quick.
Okay.
Can y'all see this screen?
Yes.
Yeah. You see?
If they make it bigger.
Oh, okay. Let me see. I don't know if I can. Let me see.
No, I just made it wider with my fingers.
How's this? Is that different? Is it a little bigger now?
Yes. Well, I made it wider with my fingers.
Oh, okay. So you see a few states, 12 states are all party consents, and everywhere else basically is one party. And you got to keep in mind that one party has to be a party to that conversation. It can't be like a secret, it can't be like another party. So one party of the conversation. So if you're in California, Connecticut, Florida, Illinois, Maryland, Massachusetts, Michigan, Montana, Nevada, New Hampshire, Pennsylvania, Washington, both parties have to consent to it. Otherwise, it's wiretapping crime. All those other states, the 38 states, one party consent to the conversation.
So I got a question. So if the debt collector states that they're recording the call, do you have to in turn inform them that you're recording it on your end as well, or you just in a two-party consent?
No. Well, if it's so now you're essentially talking about interstate law. So if I'm calling, I'm in Oklahoma, which is a one-party consent state, and so if I'm calling to California, both parties have to know, like, hey, they're recording. Like I say, debt collectors usually say they're recording the call, so that covers that disclosure. So if someone is from California is calling Oklahoma, then it's the law governing is where does the call say is landing at. So if someone is calling from California and they call Oklahoma, no, they don't have to inform anybody that they're recording.
Say it again, Vance. Not sure.
The receiving party doesn't have to acknowledge it. They have to let them know.
No.
Okay. Whoever asked that, if it's a two-party state, if anybody is in either of those states, both people on that call are all parties that's listening. That has to be consent on both sides.
On both ends, on both sides. So
both
both
sides.
Both of them have to acknowledge that or make the other aware that they are recording.
Right. So the debt collectors, they're saying it's recorded because they don't know where the person is, and technically, just because they're saying it, I don't know. That doesn't mean that's consent. It's implied consent when you continue, after you've been advised that it's being recorded, you can't say, you can't continue. You can't say technically you would need to say, I don't consent to the taping, because otherwise if they tell you they're taping it and you continue, it's sort of like an implied consent. So they just tell everyone just to cover their butts.
Correct.
So technically if you're in one of those all party consent states and someone is saying this call is recorded for quality assurance, you can say, I don't consent to the recording. They have to stop recording. Otherwise, if they continue, it's a crime in that state and a wiretapping crime.
Okay.
So
before you get off the phone, can you say I recorded this?
For what? If it's a one party state, you don't need to even say it.
No, I'm saying two-party. I live in Maryland. So.
Well, you got to do that in the beginning.
Oh, you have to do it in the beginning. And so what would they do if I said I'm recording them?
In the beginning?
Yeah.
Well, they can make a decision whether they want to continue or not. Or they could say, I don't consent to the recording. Remember, if they say nothing, that could be like an implied consent. If they say, I don't want you to record, you have to stop recording. And if you record past that, then that's a criminal act. If you're in a two-party state. If you're in a one-party state, you don't even have to say anything. You pretty much, as long as you agree, as long as you choose to do it, that's fine.
So I can walk over to Washington, D.C. and call them.
Yeah.
Okay.
And record it. That's right. As long as they're not in a
two-party state.
All parties consent state.
Washington is a two-party.
Washington, D.C.?
The state Washington. She was talking about Washington, D.C. She's about the District of Columbia. That's supposedly one party. According to this site, I'm not, like I said, I don't have these memorized. So if this site is correct, D.C. is a one-party state and Washington State is an all-party state. And so but keep in mind, if you're calling someone and they're recording and they tell you this is a call recorded and you don't say anything, then both of y'all are consenting. So everybody's covered, technically.
But my dealings with debt collectors, I've been doing, I guess, helping consumers since 2004. And so typically the bordering states surrounding Oklahoma that debt collectors collect debt in our state, typically when they hear my voice, they just hang up the phone. And it it kind of,
They know what's up with you.
Yeah. So they know I'm up to something. And so typically just when someone tells you, hey, I'm recording also, the conversation gets a little straight. No one wants to be, because under the FDCPA, let's go back. So the FDCPA is a strict liability law, so oops and uh-ohs and I'm sorry, I didn't mean to, you're still held liable. So the conversation gets a little bit straight, and so they don't want to be lying on recording. So that's why recording the phone calls is useful in when you're in federal court. So how I do it is I have two phones. So I have the latest iPhone and then my old iPhone. And so my latest iPhone, I'll just put it on speaker, and then my older iPhone, I'll just go to the voice memos and I'll just hit record and it records it just fine.
Mm-hmm. Very good.
I had another quick question for you. If somebody's having issues with back taxes and things like that, would they call you about that as far as that, or is there somebody else that they should probably contact?
Well, as far as back taxes dealing with the IRS, I think someone should go hire a CPA that handles dealing with the IRS. So as far as a credit report, I can deal with that all day. And so you just go through the procedures of the Fair Credit Reporting Act. And so you put pressure, I'm gonna just say TransUnion. You put pressure on TransUnion to produce or show you, tell you who they're getting that information from. Because if you go through the procedures of the Fair Credit Reporting Act, the Consumer Reporting Agency is supposed to contact the furnisher of the information. And so the courthouses around America do not subscribe to TransUnion, Equifax, or Experience junk, So once you get the reinvestigation results back, you got some good evidence. So I'll say I had a couple of cases that in southern Texas, basically the Houston area, we had a case where we took TransUnion. A lady had filed bankruptcy, and so we had took him to court based off of that. And so what I like to do in a complaint is be as open and honest as you can, because they'll like to use that against a consumer. So we put in a complaint, hey, this person filed bankruptcy on this day, gave them the case number and everything. And so we say, but our issue is, we're lining out and stuff like that. So that lady, like I say, she filed bankruptcy. That was true. She ended up getting $45,000 from the consumer reporting agencies because they didn't follow procedure. And through discovery, we showed that. It works the same way with bankruptcies, tax liens, judgments, any public record. It works the same way.
What is the procedure for getting that done?
Well, it's covered in Section I. Hey, Brian, can you pull up Section I of the Fair Credit Reporting Act? Well, before you talk about Section I, really you need to understand Section E-B before you kind of dive off into Section I. But yeah, so it's Section I. So if you look at Section I, so you have reinvestigation. So when you see obviously you're doing something over. So reinvestigation. So that's a compound word. So that's two words put together to make one word. So you got and investigation. So reinvestigation. And so if you're doing something over, you shouldn't have
I don't hear anything.
There we go. There we go, Vance.
Brian, can you go down to A2? Go down just a little bit, right there. Okay, so this right here, in Section A2, this is very important, and this is where the fun begins. This is the linchpin of this whole statute, where you're dealing with what was sent over, with the consumer reporting agency. So if you go, that last sentence is the linchpin. So within 5 business days, the notice, if you look at that last sentence, I'm telling you, is the winner in section A. The notice shall include all relevant information regarding the dispute that the agency has received from the consumer or the reseller. That's very important because, like I say, these are procedures. So in civil law, it's all about procedure, steps. So you just harp on that situation and you're going to win because it's mandatory that they do it. It's not an option. It's mandatory. So that's why you harp on basically that notification, however, being sent, had to be sent over to the furnisher. And you're alleging that the courthouse is the furnisher. And so you just tell the judge, hey, look, I did some independent research by picking up the phone from the number that they provided. I asked them simply, do they furnish information to TransUnion, Equifax, Experian? They told me no. And therefore, that's what prompted this action. And so that alone, that'll get things stirring up.
We asking for something specific?
Well, you can, if you go back up to 1, the 1 right there in general. So it goes, you can dispute the completeness or the accuracy of the information. You have to allege that. So you'll say, hey, this is incomplete or this is inaccurate. Usually it is because the reports that's missed, the reports that's issued a lot of the times it's a lot of stuff that's missing on the report. And so you attack that first and that gets you in the door, and then you can go through the procedures of the Fair Credit Reporting Act. And I think if you scroll down to 4, it has some pretty good merit in 4, and then also 5, because you see it says the consumer reporting agency shall review and consider. So they had to review your dispute and consider everything that you're saying. So that's a violation on that statute if they didn't do so.
Vance, to piggyback, first of all, everyone, this right here is a very important, probably one of the top.
Let me see the microphone. This is probably, I would say, one of the more important sections. But as far as number 5 here, the treatment. Can everyone hear me?
Now we can, a little better. You're kind of muffled.
Let me see. Yeah, it looks like I lost.
So I want to add to all of this. It was last week. This week or last week, it was basically a year anniversary that I basically took Experian and a furnisher to federal court over some information. And so right when I was deposing the lady that Experian provided as a witness, so Experian, so don't ever emotionally get caught up in disputing, because essentially you're dealing with a computer Like you're dealing with, it's called an e-Oscar. So you're dealing with a computer software. So don't ever get caught up into that. So what happens is you mail a dispute to Experian, and then Experian puts it in a queue over in South America. And so when I sued them, it's something Experian is going to say that is privileged and all this other stuff. You keep fighting till you get your hands on this information. Once you get your hands on this information, you will see, I mean, literally, I started laughing because that whole system is just, it's baloney. Truly, it's baloney. And so basically I was saying names like El Guardo, you know, I wasn't saying like the typical American name. And so I asked her, now this is a lady who's trained. She was super trained. And I'm like, godly. And so looking back at it now, I was 24 minutes in and I got all the information that I wanted. So she was in the United States. She basically had worked at Best Buy before she was working with Experian. And so I asked, you send a dispute to Experian. Essentially, it gets handled in South America, in Chile. And so I asked her, hey, why is El Guardo's information right here? She was just like, well, that's the person who handled the dispute. I said, oh, okay. So, and I'm like, you know, hey, do you have a passport? And the attorney, I knew I was onto something because the attorney that was sitting across, he said objection. And so when they object, the person that's answering the questions, they can still answer the question. And so I said, hey, you can still answer. And so what happened was she said, no, I don't have a passport. So therefore, Experian is just telling these people just to say whatever, you know, just say whatever under the sun. So what happened is I called a break. I went into the other room with the attorney. I said, look, this is what's going to happen. If I get back, I'm going to put a rush on this deposition. And if I get back to Oklahoma City fast enough to write basically a motion to exclude or to exclude like everything that they did and to squash everything that they did under Rule 37. And so because I was going to subpoena everybody that basically handled my dispute, and they was in South America. And so I was like, hey, I was asking for the names. Next thing you know, they didn't work there and stuff like that. And I was just like, yeah, that's a bunch of, you know, gibberish that you're talking about. So I was like, give me the last known information. That was just a fight within itself. So to say this, Experian, TransUnion, they work the same way. So you have to understand the basic rules, and that's going to get your foot in the door is learning these statutes. That case that I basically had last year settled for $300,000. And so it was just basically understanding the rules. And so in the history of Experian being in business, they have never produced anybody who handled the disputes from overseas. They never have done it. And so when attorneys and people litigate and try to get these people in America, it's you're gonna win. So, and I just seen a question come up about, am I an attorney? No, I'm not an attorney. I just happen to understand the Fair Credit Reporting Act, the Fair Debt Collection Practices Act. Basically, Brian, if you can go back to the table of contents, we can just give a quick overview of it. So it doesn't matter what kind of book it is. If you bought Brian's book, or you're reading the FDCPA, or if you're reading the FCRA, first you're going to have the table of contents. The table of contents is basically going to cut a lot of your time, because you can just say, reinvestigation procedures, or reinvestigation procedures in case of disputed accuracy. And so that's what you can go to real fast. I'm gonna just say, out of 128 pages of the Fair Credit Reporting Act, you need to kind of like know what a little bit of it is, but you probably only need to know about what 15 pages max of it is. And so it's not that complicated to understand. But once you understand it, I had 2010-ish, I had like 3 or 4 cases against TransUnion, and I won them cases. It's very simple. Once you understand the rules, they're really intimidated by someone that's just not going to take no for an answer. So if anybody got any questions or anything like that, we can I'll be happy to answer your questions.
Oh, okay. Can y'all hear me now? I got my
Much
mic.
better.
Okay. My mic went off. I wanted to finish my thought for those that are listening. I was saying on 1681I, A5, a lot of people forget in their disputes to address the treatment, how you want them to treat that information. Remember, you need to tell them they need to either what? Delete or modify it. So be sure, and a lot of people leave that open. And actually, it hurts me so much when I see people say, reinvestigate. The call to action they say is reinvestigate, but they fail to really direct the agency on what you demand. Your demand is not a reinvestigation. They have to do that by law. You want them to delete or modify. And you'd be surprised how many people leave that out, but be sure to have a call to action on what you want them to do. And of course, the other 2 keywords up top here, you want to dispute the completeness or accuracy. So that means you want to call something incomplete or you want to call something inaccurate. So those 4 words should be in your letter. And those of you that have my book and letters, those words are automatically included, and all you put in is trade line information. But I just wanted to sort of piggyback what Vance was telling you, and be sure you hone in on those key words. So Shayla.
Excuse me. On working efficient artificial intelligence, EOSCR, are there certain words that you can use?
Yeah, they pick up on those words I just mentioned. They pick up like inaccurate, incomplete. They pick up on those words. Okay. Even if they don't pick up on it, as long as you have those words, you situated yourself. But Vance, I know you have your own letters. You can tell them about these keywords that you be sure to use.
I have a question.
Mm-hmm.
With the EOSCR, I've heard that that it don't matter what font or color you use. I've heard about them recommending to actually write by hand some part of it, so it'll actually go to a person and get a lot of stuff either deleted or updated from the first round. What do you think about it? I mean, is it true? Is it not true? What are your recommendations? Or
Vance, I type write everything, Vance, but go ahead on Vance. Vance, you're muted. Hold on. There you go.
Okay. Sorry. So, no, that's not true because, okay. So if anybody has a smartphone, when we get off this Zoom call, what you can do is just go to say if you have an app, the App Store. The App Store, I think it's Google Play or something like that. So if you just put in OCR, just put in OCR into your App Store, whatever the case may be. It's called optical character recognition, and so is trained, or it's a system that scans any type of font, and it's gonna and you can program it to pop out, and so every time this document has and in it, it will pop it out. So that's the technology used, is it's called OCR, optical character recognition. And so no matter if you do it cursive, it's going to be able to pick it up. So no matter if you do it Old English, it's going to be able to pick it up. So I don't think, doing pink paper, yellow paper, I don't think any of that is sufficient,
I heard some of the philosophies where they say if you do something like that, it will kick the paper out and someone have to read it in their hands, put it in their hands and read it.
Well, let's say if that's true. So it's the system is still able to pick it up. So what happens is when you sue, if you really want to know what really happens, you have to sue, say, let's pick on Equifax. So Equifax works with the company. So let's say TransUnion. So TransUnion works with the company in India. And so the mail is forwarded. Typically, people dispute at a P.O. box or the physical address in Pennsylvania. So from Pennsylvania to the mail gets transferred to India. And so it's a building in India. So that's open up for like 12 hours a day. And it doesn't matter how many people is working or whatever, it only gets paid 55 cents per letter that it opens. It doesn't matter how many people is in there, 55 cents per letter. And so so we had a case in 2007 that was dealing with Bank of America. And so when TransUnion, Equifax, or Experian sends over what's called, it's an acronym for it. My mind went blank. ACDV, Automated Consumer Dispute Verification. When it sends over that notification, it's like 35 to 55 cents per transaction. So it just depends on what it is. So, like I say, in 2007, we had a Bank of America, and we asked them in ACDV forms in the cost, how much money have you given TransUnion? They said $7 million. So that's big business. So they're not, want to shy away from a pink letter or somebody open it up, and it doesn't matter. So that mail is going to get transferred, go overseas, get transcribed into a 2-digit code basically, and come back to America. And so what people really don't understand is when someone opens up reinvestigation results from TransUnion, it's coming from an address in Chicago. So if you look and listen to what I just told you, people typically send a dispute to Pennsylvania. But the results from the reinvestigation results, when you open up that mail, if you look in the top corner of it, it's coming from Chicago. That's where TransUnion's headquarters is. And so it's a lot of things that just happens with technology. But the answer to your question, I don't think it has a bearing on how their system works. I even heard of people stapling
and stickers too.
Yeah. I don't think it has a bearing.
Okay.
All right. Well, shoot. Great discussion. Hey, thank you, Vance. Thank you all that attended. And we'll do this again, of course, soon. We'll have another topic, another night. Everybody stay safe. And of course, God bless America.
Thank you.
Thank you.
Appreciate
Thank
it.
you very much.
Absolutely.
Thank you.
Absolutely.
Thank you.